Welcome everyone to today's webinar. My name is Kate Mealy. My pronouns are she, her, and they, them. I am the linkages coordinator at CJE, and I will be hosting this program today. We are working on getting the captions set up. Please click on the closed caption button at the bottom and choose either subtitles or transcript for your viewing preference if you'd like those, and hopefully they will get started. So please be aware that this program is being recorded to be shared on our website. If you provided an email when you registered for the program, you will be sent a follow-up email with the link to this recording on our webpage, as well as any other handouts or documents that are shared today. We will also send you a link to our evaluation survey, so please fill that out after the program. We truly value your feedback. Since this program is being recorded to be shared publicly, there are higher privacy features in place, and your live participation will be anonymous. So you will not be able to see other participants, and when you use the question and answer feature, your name will not be shared. We do encourage you to participate and use the question and answer feature at the bottom of your screen to ask questions. And before we begin today's presentation, I'll take just a moment to share information about our Linkages program. Linkages is a CJE Senior Life program that provides information to older adults who have adult family members with disabilities. Linkages provides community educational programs, information and referral, and a support group. If you would like to join the support group, please call 773-508-1327 for more information. The meetings are scheduled on Zoom the first and third Wednesday of every month at 3 o'clock Central. Finally, for today's program, I would like to thank Hannah Walsh, our speaker today. Hannah Walsh represents clients in disability discrimination cases under Titles I of the ADA and analogous state and local laws. Hannah manages Equip for Equality's Employment Rights Helpline, which aims to expand employment opportunities by providing legal and practical advice to applicants and individuals with disabilities. In furtherance of this effort, Hannah provides trainings on employment rights for people with disabilities under the ADA. Hannah is also the program manager for Equip for Equality's Protection and Advocacy Agency for Beneficiaries of Social Security Program and addresses barriers to employment for clients who are Social Security beneficiaries. Within Equip for Equality, Hannah also serves as the co-chair for the Disability, Equity, and Inclusion Committee and co-liaison for the Council on Mental Health Disabilities. Prior to Equip for Equality, Hannah worked at a plaintiff's employment firm, handling litigation on a wide variety of discrimination issues in state and federal court. Before law school, Hannah obtained their bachelor's degree in deaf studies at California State University, Northridge, and worked as a support service provider for individuals with combined hearing and vision disabilities. While obtaining their law degree at Chicago, Kent, Hannah was a Pilley intern with Equip for Equality and a law clerk in the Disability Rights Bureau of the Attorney General's Office. We are so lucky to have Hannah with us today. And with that, Hannah, I will hand it over to you.
Okay, great. Thank you so much, Kate. I'm going to share my screen really quickly and just get that set up. I also just kind of want to say, before we get started, let's see, hold on. I don't usually have this problem in Zoom, but I just want to make sure y'all can see the slide transitions. Can you see me moving between?
Yes, it looks great.
Okay, so it's usually just Teams that has that issue. Okay, so usually I love answering questions during a presentation. But we have like a set time at the end for questions. So I think while you can absolutely put questions in the chat and Kate's gonna like moderate that, I probably won't answer them during because I can be a little long-winded and I just want to make sure I don't like go over on time. So there is appropriate time to ask questions. One last thing, because I see she's one of the attendees of this. I just want to give a shout out to my cousin, Lindsay Somberg, who is a social worker with CJE, and she connected me and initially with Kate, and so that's kind of why I'm here. So thanks, Lindsay. Okay, so today I'm going to be talking about the rights for workers with disabilities, mostly focusing on, what the laws say people's rights are, and I hopefully can kind of put this through a lens of the particular people that we're talking about here right now, right? Which is elder adults. I believe it's like the parents of most of the people in attendance here. And yeah, so we'll get started there. I wanted to first give a little bit of a background on the organization I work for, because I'm not sure how many people have heard of Equip for Equality. We are a disability rights legal organization. Our mission is to advance the human and civil rights of people with disabilities in Illinois. Our services are free, and we serve people with all disabilities of all ages across the state. So as long we don't have income limits or anything like that, as long as someone has a disability and has an issue related to their disability in Illinois, we can provide services. We're a private, independent nonprofit. However, we are also federally mandated and funded. So that's where we get most of our resources from, is the federal government. We're a private, independent nonprofit. Every state has a version of us. So if you or your loved one, your parent, end up moving to a different state, there is a version of us in every state. So our name is, I think, a little silly. It doesn't tell you what we do, but like, let's say you're in Wisconsin, there's Disability Rights Wisconsin is our sister agency there. We have offices across the state, Chicago, Carbondale, Springfield, but we serve the entire state. And we're split into 3 different divisions. So we have a special education clinic for parents and students with disabilities navigating the IEP process, due process hearings, that kind of thing. We have, I should update this. It's called the Independent Monitoring Unit now, but they do investigate instances of abuse and neglect of people with disabilities. And we also have the civil rights team. It's kind of a catch-all anti-discrimination team. That's the team I'm on, and that's the team that our employment helpline is under. So a little bit more on the employment helpline itself. We created it, 6 years ago now, because I was initially hired as an attorney to staff it when it was first created. And the purpose of the helpline is to help people understand their rights under the Americans with Disabilities Act, answer any employment rights questions, help people understand their options. We've created a large database of like fact sheets, sample letters, forms that we can share with people on employment issues. We have a big database of referrals. And so, a lot of what we do is provide kind of advice, behind the scenes assistance, because our organization is a big advocate for self-advocacy, like supporting self-advocacy and supporting people with disabilities, learning about their rights and advocating for themselves. But we are able to do other things. We can accept cases to send demand letters, mediations, up to litigation. So we do a variety of things. I think I said this before, but it's worth noting again, our services are free of charge. All you have to do is contact us and go through the initial intake process. If it's an employment case, you'll probably be working with me, or I will be at the very least supervising the case. And I've provided some contact information here specifically for the helpline. Now, if you end up having other issues that aren't related to employment, but they're related to disability issues, you can still call one of these numbers. You'll get rerouted to the appropriate team within Equip for Equality. Okay, that's done with the background. I don't think I need to tell you anything about me because I think Kate covered that pretty well. So we'll just get on to kind of the meat of the presentation, which is employment rights under the Americans with Disabilities Act and other similar laws. So the Americans with Disabilities Act, or ADA, was passed by Congress in 1990. We're exactly the same age, and the goal of addressing discrimination issues for people with disabilities, providing equal opportunities for people with disabilities, and also helping people with disabilities find and keep jobs. Now, the ADA has done a lot. I mean, I don't want to understate that, to help people with disabilities have equal access to a lot of aspects of life. One area where we haven't seen as much improvement is in the employment area, in an increase in employment rates for people with disabilities. It hasn't changed as much as we would have hoped in the past 33 years. Which is why I do these presentations. I feel like the more people know about their rights, the more they're able to advocate for themselves, the more they're able to use the law to their benefit in employment situations. Just briefly, there are a lot of similar laws. There's another federal law called the Rehabilitation Act. There's a state law called the Illinois Human Rights Act. There's local laws, Cook County Human Rights Ordinance, Chicago Human Rights Ordinance, that all have very similar, include similar rights for people with disabilities. It's just kind of easier to talk about this as the ADA because most people know what the ADA is, but please just note when I say that, I'm kind of talking about all of these laws. Okay, so who's protected by the ADA? In order to be protected by the ADA in its employment provisions, you need to be a qualified individual with a disability. So disability has kind of a seemingly complicated definition under the law. I want to go through it and just kind of break it down because it really is not that complicated and shouldn't be, and it's not a high bar to show you have a disability. So under the law, an individual has a disability if they have a physical or mental impairment that causes a substantial limitation of one or more major life activities. Now, something I see sometimes with people, which is totally understandable, especially people with newly acquired disabilities, is they don't see themselves as a person with a disability, right? They don't see their medical condition as a disability. And that's totally fine. You know, it's a personal decision how you want to identify. However, I just think it's important to know that a lot of medical conditions, especially medical conditions that maybe you acquire as you age, at least for the purposes of the ADA and getting rights under the ADA, probably constitute a disability. So I just think that's good to know because you can still utilize the rights of the ADA with these medical conditions. So again, I'm breaking this definition down: physical or mental impairment. So physical covers kind of anything outside of like a mental health condition, and mental health conditions also can constitute disabilities. So you have to have some sort of medical condition, right, that causes a substantial limitation of one or more major life activities. All that really means is, let's say you have like some degenerative disc disease, and that impacts your ability to walk or sit or stand. All of those things are considered major life activities. So if you have what's considered a substantial limitation, which essentially is just like you might need some extra support or help, then you have a disability under the law. Major life activities can include a lot of different things: breathing, sleeping. This seems weird, but it even is meant to be very broad to encompass things like if you have cancer, irregular cell growth or cell growth is a major life activity. So because you have irregular cell growth, that can be a disability. Again, this is not meant to be a high bar. Most medical conditions, if they have an impact on someone, can be considered a disability. Also, a limitation on your ability to work. Work is a major life activity. So that in and of itself can constitute having a disability. The ADA also applies to people who have a record of impairment. So let's say, going back to cancer, you had cancer, but you've been in remission for a couple years. Your employer finds out that you had cancer and fires you for that reason. You're covered by the ADA because you have a record of that impairment. Same is true. Well, I don't know that we necessarily see this as often, but let's say your employer thinks you have diabetes and fires you for thinking you have diabetes. You don't actually have diabetes, but you get fired for that reason anyway. You're covered by the ADA because you were regarded as having a disability. Again, these two things don't come up as much. I think the definition of disability is most important, but I think it's good to cover everything. Okay, so once we've established you have a disability, pretty easy to check that box. In terms of being covered by the employment provisions of the ADA, you also need to be qualified for the job. So that means the obvious things, right? Like you have to meet the job requirements, education, experience, licenses. I'm a lawyer. If I hadn't gone to law school and passed the bar, I wouldn't be qualified to be a lawyer. It doesn't matter what else went on in like that interview process or whatever. I'm immediately like not covered because I wasn't qualified for the role. And then you have to be able to do the important parts of the job. So the essential functions of the job with or without a reasonable accommodation. And that's the important part. And I'm going to get deeper into accommodations, but you know, like the world, a lot of workplaces are inherently inaccessible to people with disabilities. So even if you can't do a job as is, if there's an accommodation that would allow you to do it, then you're qualified. Okay. The ADA considers is very similar to other anti-discrimination laws, right? So now we know you're covered. The protections of the ADA include kind of all aspects of employment. Again, very similar to other anti-discrimination laws, except it includes it broadens people with disabilities rights specifically in two ways. So normal things like job application process, hiring, firing, benefits and compensation, advancement and training, you're covered if you're discriminated against in those areas of employment. Where the ADA differs and expands rights is that refusing to provide a reasonable accommodation that in and of itself is considered discrimination under the law, as well as certain medical exams and inquiries by employers, which I am also going to get into more. But this is kind of a list of how and where in throughout your employment you're protected from discrimination. Okay, this is maybe not like new information for you, but I do think it's kind of important that we focus on like what discrimination actually means in the context of laws and violating those laws. So discrimination is considered being treated unfairly or differently because of a specific characteristic. And there's a difference between just kind of normal discrimination, like just that in and of itself, and illegal discrimination. So in this silly hypothetical, we have Anna who applies for a job during her interview and tells the interviewer that she has 3 cats. The employer hates cats, hates all people who own cats, and she is not given the job for that reason. Was she discriminated against because she has cats? Yeah, I mean, it falls under the definition of discrimination, but having cats is not protected by law. Like being a cat owner is not something you're protected from discrimination against. So it wouldn't be illegal, and the employer could absolutely do that, despite how bizarre it is. When we're talking about discrimination under the law, it's discrimination based on people's status in a protected class. So protected classes obviously include disability, and then other classes such as race, ethnicity, gender, religion, depending on the state. So like Illinois covers sexual identity and gender identity and sexual orientation. State laws often tend to be a bit more expansive on who is covered. But yeah, only discrimination against people in those protected classes because of the fact that they're in those protected classes are considered illegal discrimination. That being said, employers don't have like an affirmative obligation to hire applicants specifically because they have disabilities. They can consider them as they would anybody else, but there's no like affirmative obligation to hire people with disabilities. I personally think the reason we haven't seen more progress in employment rates of people with disabilities since the ADA passed is because there's no like affirmative action hiring provisions. I think that would solve a lot of these problems, but it doesn't exist, so that's what we have to work within. Now, certain employment entities such as the federal government, they do implement affirmative action hiring procedures. So they are meant to be hiring more people with disabilities. Some other employers will do that as well. That is their choice. They can absolutely do that, but they don't have to. Okay, now I feel like we have a good background on what the ADA is, who's covered, what discrimination is. Now I kind of want to get more into the aspects of the ADA that I personally see coming up a lot with clients and that I feel like is kind of most important to know so that you can protect yourself in the workplace as a employee with a disability. So now we're going to get into disclosure rights under the ADA. Okay, so question. You are in a job interview. Do you have to say that you have a disability? The answer to that is no, you absolutely do not. In particular, at the interview stage and application stage, you have no obligation to share that with an employer. It is not considered lying. Even if you decide to disclose later to get accommodations, like you do not have to. That is your personal information that you don't have to share. Some employers try to get mad about it later, but legally they cannot. I think a different, more difficult question is, should you share you have a disability? And that's tricky because we want to hope that employers aren't going to discriminate, right, against people with disabilities, but the reality is that they do. So me personally, for the most part, and there's some exceptions I'm going to get into, I often counsel my clients to not disclose until they already have a job offer. If they want to disclose or if they need to get accommodations. I think it's just a best practice, mostly because at the interview application stage, your employer could give a bunch of reasons for not hiring you, right? And it would, how do you know if it's true or not, right? How do you know if they're being they didn't hire you for a legitimate reason or because of your disability? You can't really know that, and it's hard to get the evidence to prove that. That's why the law says you don't have to disclose your disability. I also need to put a tiny caveat, but we're going to get in later. The only time you do need to disclose your disability at the interview stage is if, let's say, you needed an accommodation for the interview. Let's say you have a hearing disability, you need to have CART services, or you need an interpreter. You would have to then disclose that you have a hearing disability in order for them to give you that accommodation. Besides that, don't have to disclose. I feel like there are some situations where maybe you should share. If you're applying for a job at Equip for Equality or the federal government, right? Having a disability is an incentive to hire at certain organizations. So that might actually help you get the job. But that's something definitely to research beforehand. Some of my clients just say, I don't want to work for an employer that would discriminate against me because of my disability, so I'm going to tell them. And that is 100% their right, and I totally understand that thought process. And again, you can disclose the information if you want to, you just don't have to. One other thing that I think kind of comes up is if a disability is obvious. Obviously your employer's going to know then, right? If you have an obvious disability. My kind of thought process on that, I think kind of the best way to handle it is to potentially acknowledge it and then say, obviously I have this disability, but here's all the ways I'm qualified for this job, and here's why I think, having a disability might be an asset, something like that, and just kind of pivot. So yeah, it's really a personal decision at the end of the day, but I tend to lean towards don't disclose if you don't have to. So I kind of touched on this a little bit, but your disclosure rights under the law differ depending on what stage of the employment process you're in. So it kind of gets broken down into 3 stages. Stage 1 is this pre-employment application and interview process. At that point, as I said, you don't have to disclose your disability. Employers can't ask disability-related information. They can't give medical exams. They can't even ask questions that might kind of force you to provide disability-related information. So like, did you have to take a lot of sick time at your last job? In order to like properly explain why you may have done that, you could be forced to disclose your disability, so they can't ask questions like that. There are some exceptions. If they have affirmative action hiring practices, and on their like job application, there's a page that asks those questions. Usually it's like disability, race, veteran status, maybe gender. That's okay as long as they make it very clear that these are voluntary questions you don't have to answer, and it's for affirmative action hiring. That's kind of the exception to that. Employers can ask, are you able to perform specific functions of this job? Can you describe or demonstrate how you would do that? That's kind of the limit there. Now, the second stage is after you get a conditional job offer, and basically the disclosure rights kind of get flipped on their head. Employers can ask really any disability related questions. They can require a medical exam, as long as these things are done to all applicants. They're not singling out people they think have a disability. And the reason for this change is, I think I kind of said this before, in the application stage, your ability to prove the discrimination is so low, it's so difficult to do that, that it would be almost impossible. I mean, unless employers are dumb and specifically say it, which sometimes they are, but most are smarter than that. It would be, most of the time, it's really hard to prove discrimination. At this stage, you've been given the job offer. They found you qualified. They found you to be the person they wanted to hire for this position. You have the job. So the only thing at this point that could result in you getting that job offer withdrawn would be these potential disability questions, issues that come up. Maybe an exception to that would be if there's some issue with your background check. But for the most part, like if they're asking disability questions and then they decide to withdraw the job offer, you can be like, it's because I have a disability. I had to disclose it to them. Nothing else has changed. And so you can prove the discrimination case. Now, if, for example, and most of the time employers cannot withdraw that job offer unless the disability prevents someone from like performing the essential functions of the job, and there's like no accommodation that could be provided. So like one example of this, and most of the time I don't think this would come up, and I don't think they would have a valid reason to do this, but like let's say you have a vision disability and you don't have a driver's license because of it, but you apply for a job and get a job that involves driving. Like maybe that's the main thing you do. If they then find out about this vision disability, they could probably withdraw the job offer because there's no accommodation that could change the fact that you are not able to get a driver's license. That's kind of one extreme example I can think of, but I think most of the time they would have a hard time finding a valid excuse. Okay, the third stage of this disclosure situation is once you're actually an employee, once you've actually started working. In that case, employers can only get disability-related information when it's job-related and consistent with business necessity, which is just a overly complicated way of saying they need to have like an objective, reasonable basis to think either you're not qualified for the job because of your disability. So like observing things that like most people would consider like concerning about you being able to do the job, or if there's an observable direct threat to the health and safety of other employees, then they could potentially ask for medical information to confirm you can do the job or can do the job safely, or if you need an accommodation. So if you decide, okay, I need accommodations at work to effectively do my job, and you ask for them, employers can then require medical documentation of your disability to confirm you have one and that you need accommodations. So it's kind of like a mix in between the first and second stage. Looks like there's a lot of stuff going on in the chat and Q&A. but I'm willing to talk about anything from the past at the question and answer session at the end. Okay. And I'm doing okay on time, but not amazing. So I'm going to try and pick it up a little. One thing I think it's important to know, because we're talking about disclosure and the possibility of employers having medical information about you, is that the ADA also has confidentiality rights. I think in some ways kind of similar to HIPAA. HIPAA doesn't apply to the employment situation, but the ADA has its own confidentiality rights. So all disability related information needs to be kept confidential. You're supposed to have a medical file that's separate from your personnel file, and they can only tell people who need to know. So like, let's say you need accommodations. Who are the people that are going to facilitate you getting those accommodations and making sure that they work? Those people can be told so that they can facilitate your accommodations. The exception to this is for what's considered a voluntary medical disclosure. Requesting an accommodation is not considered voluntary because you have to disclose to utilize your rights. But if someone just like went into a workplace and just decided to tell people about their disability, like their coworkers, and they weren't requesting accommodations, and then that gets spread around, that's considered a voluntary disclosure, and it's not protected by the confidentiality provisions of the ADA. Okay, now I want to pivot a little to reasonable accommodation rights. To me, and I just think this is kind of a obvious objective thing, the accommodation rights and provisions under these laws for people with disabilities is kind of the most important part of the law, at least in the employment section, because again, like the workplace is very often inherently not accessible to people with disabilities, and without a right to accommodations, most jobs would be unavailable to people with disabilities. So this is kind of the biggest tool we have to ensure more people with disabilities can work. So as I said before, it's considered discrimination not to provide reasonable accommodations. So employers have to give applicants and employees a reasonable accommodation. Accommodations could be, as I said, something you need for the application or interview, something to make sure you get equal access to benefits of the jobs. But the main thing we see accommodations asked for is because you need a change to how you specifically do a job. And that can be a variety of different things that I'll get into a little bit more. Hold on, I just want to make sure. Okay, I do have a slide about it. Okay. So, some people, let's say someone's had a disability their whole life, so they may know what kinds of accommodations they need on the job. And so once they get a job offer, they may feel comfortable saying, hey, I need these particular accommodations to do this job. But not everybody knows that. Every job can be different. Some people acquire new disabilities and may not know what's going to happen. So you can request accommodations at any point in the process. There's no limit on the amount of accommodations you can request, or like if your needs change, you can ask for new ones later. It's an ongoing duty to accommodate. And it's a process requesting accommodations, right? So the first step typically is the person with the disability proactively reaching out to the employer and saying, I'm a person with a disability. I need accommodations. Here's my suggested ones. And that's kind of normally the starting point. It might take time though after that to figure out an accommodation that is effective for you, doesn't cause called an undue burden under the law for the employer. And I think it's important to note that like not every accommodation is going to work for everybody, even if you have the exact same disability. Like people who have ADHD, you may have 10 people with ADHD who all need different kinds of accommodations. And the employer must consider that. They must consider people on an individualized basis. So I just, okay, no, I'm just making sure. Okay. The kind of overall goal of the accommodation process is to find an accommodation that works for you, your employer, and your ability to do your job. There are some cases where an accommodation might not be considered reasonable and an employer wouldn't have to provide it. And those circumstances are if you are asking for an accommodation that eliminates an essential function of your job, that is never considered reasonable, and employers don't have to do that. You can ask for accommodations to help you do the essential function of the job, but not to eliminate it. The other potential issue that can come up is cost. And that can differ, right? So if you need a piece of equipment to do your job and you work for Walmart and it's like $1,000, that's probably not going to be considered an undue burden for Walmart. If you need that same piece of equipment for like a smaller, like mom and pop shop, it might be considered an undue burden. It kind of depends on who the employer is. Okay, I have some examples here of accommodations. This list is by no means exhaustive. Really anything can be an accommodation as long as it works for you. So the limit does not exist on what can be an accommodation. But here are some ones that we see a lot, potentially modifying the workplace to be accessible, building ramps, widening doors, sign language interpreters, screen reading software for people with vision disabilities or learning disabilities, maybe a flexible work schedule, removing non-essential tasks, getting extra breaks, maybe getting a job coach, giving directions in writing, giving directions verbally, depending on what people need. Leave can be considered an accommodation under the ADA. Reassignment can be considered an accommodation. Telework can be considered an accommodation. Again, anything can be an accommodation. Whether or not it's reasonable depends on your particular job and your particular employer. Just a brief aside, but telework is one of those. Oh shoot, I'm running out of time. I'm not going to do that. Okay.
Hannah, you can take as much time as you need to. I'll make sure to pop in with questions. So feel free to share. Thanks.
Cool. Okay, sorry. I try really hard, but I just can't. It's difficult for me to be brief.
You're doing great.
Thank you. Okay, so just a brief aside, because telework I think is going to be a big kind of deal in employment law issues and cases moving forward. Because prior to the pandemic, courts did not like telework. Usually it was not considered a reasonable accommodation. Employers could kind of make up a bunch of silly reasons that didn't really matter. Like vague workplace culture claims that like the courts were like, okay. But since the pandemic, I think that we're going to see a shift because now employees have been able to prove that they can do most of their work from home, if not all. Obviously not all employees. If you work at a grocery store or a movie theater or something like that, you can't work remotely, but a lot of other jobs can be done remotely. And I'm seeing a good amount of employers embracing this. And then I'm seeing unfortunately, also a good amount of employers completely doubling down on this like working in person requirement. And I think that now we can kind of prove that that is violating the law. Telework can be a reasonable accommodation. And the cases litigation moves slowly, cases are coming out slowly, but we are seeing a better shift in this trend. And I think we're going to continue to see that. Okay, so what's the process for asking for a reasonable accommodation? Now, you don't have to do this in writing and you don't have to like use these specific buzzwords, but you should. Okay, as a lawyer, I personally think everything kind of important in the employment context should be done in writing. So your employer can't turn around and say, no, you didn't ask for that. So make a request to your supervisor or HR, make it in writing. You can talk to them first, but then make sure and follow up in writing. Use buzzwords like ADA and reasonable accommodations, like I am requesting a reasonable accommodation under the ADA. We have a fact sheet on requesting accommodations that includes a template letter. It's on our website, but also if anyone just wants to reach out to me directly, I can just send it to you. And we have modifications of that for a number of different kinds of accommodation requests. So that's there as well. Here's just kind of an example of what a written request could be. I'm deaf and need an American Sign Language interpreter to understand what people are saying at meetings and for all trainings. I'm asking for an ASL interpreter as a reasonable accommodation under the ADA. I think that would be a great verbal and then follow-up written requests or just written. Now, employers, once you make that request, they don't have to automatically give it to you, right? They're supposed to engage in an interactive process and work with you to figure out, like, well, if they need medical documentation, if they're going to request medical documentation to confirm you have this disability and you need these accommodations, if your request is reasonable, or if there are alternative accommodations that can potentially work. And employers can sometimes do that. All their obligation is to provide an effective accommodation, not necessarily a preferred accommodation. So like, let's say you have a learning disability, you ask for in-person CART services, so captioning services for every in-person meeting. And the employer's like, well, that's going to be kind of expensive. We're going to buy this piece of software, like dictation software, instead for you to use at meetings. If it works, that's great. They provided an effective accommodation. That's all they have to do. If it doesn't work, then they haven't done that right. And the employer might have to go back and reevaluate and figure out and potentially provide what you asked for, those CART services. It just depends on whether or not what they give you is effective. Okay, and then after your accommodations are granted, your employer has an obligation to then implement them. And as I said before, the duty to accommodate is ongoing, so you may need to modify current accommodations or get new accommodations. I think, there can be a number of reasons why you may want to do this. Some people have medical conditions that are like progressive, right? So like macular degeneration, it like over time, you slowly lose more and more vision. So like when you start a job, maybe you didn't need any accommodations, and then a couple of years in, maybe you do need some because of the vision, the progressive vision loss, and then maybe a couple of years after that, you need even more. That's okay. The law allows for that. That's kind of my overview of accommodations. I do have just like a couple slides on the Family Medical Leave Act, because that can also be relevant. I'll just go through this briefly though. So essentially, if you work for an employer that has 50 or more employees and you've been there 12 months, so a year, pretty much full time, and either you or an immediate family member has what they call a serious health condition, then you are eligible, not only eligible for FMLA, you are entitled to it. And it can be for a family member. I think most people think about using it for family members' medical conditions because it's called the Family Medical Leave Act, but it also applies to an individual person. So as long as you're eligible, you are entitled to 12 weeks per year, 3 months of leave. It's unpaid leave, but it's 3 months of leave. You could potentially get more leave as an accommodation on top of that under the ADA, although the courts have kind of limited that. But so FMLA, if you're eligible, can be a great way to take leave for, a variety of reasons related to your health. Let's see. Yep, they have to provide it. They can require you to use like your accrued leave while you do that. They don't have to pay you, but they can say you have to use like your PTO. And I think I kind of covered the rest of it. So that's basically the end of my presentation. Although I do want to just do a quick, basically highlight on a particular government entity, Illinois government entity called the Division of Rehabilitative Services, or DRS. If you have a disability and you maybe are trying to get back into work, you need help getting back into work, or you are working, but you need extra support, this government entity, you have to apply for services and become their client. But they have a bunch of money specifically to help people with disabilities work. And there's no age cap on this. I was talking to a DRS counselor who had a client who was like in their early 90s. Like, there's no age limit on these services, and they can help people get like technology they may need to work, get specific evaluations to figure out what needs they have in the workplace. They can help with transportation and housing as long as it's like furthering the goal of employment. They can pay for like a training program, or even, they'll pay for like your bachelor's degree too, but they can also help find a job, do like job training, job coaching. So it's just a good resource. Now, sometimes the counselors are not very good and they don't give you the services you want. If that ends up being the case, contact Equip for Equality, because we're also the designated entity that oversees DRS and helps people advocate for their rights to get services from DRS. But I think when they are working effectively, it's an incredible resource for people to help them work. Okay, Centers for Independent Livings can also help with these kind of things. I've provided information about this and a link to where you can find yours. My contact information, Equip for Equality's contact information. Okay, the end. And there's still some time. I didn't go I went 7 minutes over, so that's not too bad.
Not at all. Thank you so much, Hannah.
No problem.
There was so much information in here. We do have a couple questions. If anyone has thought of new questions, please add them to the Q&A. So why don't we start just going through them? So first, what can I tell an employer about any incentives that they can get for hiring a person with disabilities?
I think it can depend on who the employer is. I mean, I feel like employers who are actively trying to hire people with disabilities already know that. I think if you're talking about like on an individual basis of like how your disability has made you like more qualified for certain roles and stuff like that, like how those could be benefits. I'm not sure I'm fully understanding the question, but this is what I think you're asking. Like, I think, so at my organization, and I think a lot of, especially in the nonprofit field, right? Having a connection to the communities of people that you work with is like having a personal connection can make you better at your job, or just having an understanding in a personal way can, I think, provide more empathy and understanding, and that can be helpful. And I think that's something to share with employers if it's relevant. Like I have disabilities, a lot of people I work with have disabilities. Like my organization in particular thinks it's a benefit to our work environment to have disabilities. Like not everyone's going to think like that. I don't know that there's like particular like other outside benefits. Like I don't think they get like tax credits or stuff like that. I'm honestly not really sure. I hope that answered your question.
Yeah. So ensuring that they see the value add that you bring. It's not a limitation. It's a different perspective that can bring extra value.
Yeah, I think that's a good way to kind of approach that if you are talking to your employer about a disability.
Excellent. Someone asked, they were referred to Department of Rehab Services to get a job coach. They asked for medical and more records. So why can they do that?
Yeah, DRS is allowed to ask for, it's kind of like the same as employers being able to ask for your medical records. One, to show that you do have a disability and you need these services. But I think in particular for DRS, getting your medical records and all that information can help them figure out what services you may like benefit from through them, helps them kind of individualize their focus on what they're giving to you because they know what your disabilities are and what you need from them. So that's why they can do that. And I think if you don't, then they don't have to provide services, unfortunately.
Okay, that's helpful. I think similar to the first question, do you have advice on what to look for when you're applying for jobs if we want to work for a place that is inclusive and not likely to discriminate against people with disabilities? So
yeah, I mean, I think now I take this with a grain of salt. When employers are asking those voluntary disclosure questions, I think and I hope the intent is because they genuinely want to hire people in those protected classes, right? I don't know. I worry that somehow they're supposed to keep that like information separate from the interview process and like decision-making process. And I hope that that is always true. sometimes I worry that maybe they use that information in a bad way, even though they're not supposed to. But I think if you want like it might be one thing to consider when you're applying for jobs is if they are like actively trying to hire people with disabilities, veterans, that kind of thing. Another way to do this is research the companies, I think, see if, a lot when there are lawsuits that happen, that information is often public, information from court and cases and stuff like that is public. So see if they have been, if complaints have been filed against them for discrimination, that kind of thing. Talk to maybe your communities of people, if you are in connection with communities of people with other disabilities, like ask them, have you worked for employers that you think are good towards people with disabilities? I think that kind of the more research you can do from different sources ahead of time is a good idea. But the tricky thing, I think, at the end of the day is you can have like a company that is generally very good about not violating the law and how they treat people with disabilities, but then there could be like one bad person in hiring that decides to do that. So like I think there's always a risk, but I think there are some ways you can do some research on this.
And then there's a question, I don't know if this is in your expertise, but any advice on working and not losing benefits?
So I specifically kind of do help people with this particular thing. The grant we have doesn't cover SSRI or like Social Security retirement income. I don't know if there's limitations on working with SSRI, and so I can't speak to that. But if someone has SSDI, Social Security Disability Insurance, or SSI, supplemental security, and I don't know, SSI. Basically, those are the two kinds of Social Security you can get for having a disability specifically. If someone has those, there are, obviously there are limits on how much you can work, essentially because of how much money you can make and still keep your benefits. In order to do that, I think part-time work is often the solution, but sometimes you don't always have control over your schedule. I would say, and you can't ask for an accommodation from an employer to limit your hours so you don't lose a benefit. You can only ask for an accommodation for something related to your disability. So let's say your disability is limiting your ability to work a certain number of hours, and also you don't want to lose your benefits. Ask for the accommodation, but only mention your disability related need. And then they may have to provide that. And then so you have a limit on the hours you're working so you don't lose your benefits. There are also organizations that are funded by the federal government that are specifically there to help people with disabilities work and keep their benefits. And they're like benefits experts. So like, I don't know all the ins and outs of this. They do. They're called WIPAs, Work Incentive Planning and Assistance Programs. And there are 3 that cover the state of Illinois. You just look up WIPA programs in Illinois or Work Incentive Planning and Assistance programs in Illinois. You should find them. And they have benefits counselors because there are a lot of ways that you can count down your income so you can keep your benefits. So if you end up using money to go to work, you have copays on medication, those kind of costs that you pay that you have to in order to work can be deducted from your like overall countable income and keep you under the limit for things like Social Security. So that is WIPAs are an incredible resource, and I know because overpayments are horrible and we want to avoid them at all costs because the Social Security Administration sucks. Even though they fund a program I run, they are one of my work enemies because most government entities are my work enemies, but Social Security Administration will not notice an overpayment for like 3 years and then hit you with like a huge overpayment. And it's like, if you had just told them when it happened, they wouldn't have a $40,000 overpayment. And to me, that's inexcusable, but anyway.
Hannah,
So yes, WIPAs
that
are.
was a really helpful answer. Yeah.
Okay.
In general, I mean, this has been such a great presentation. I feel more empowered to help people advocate for themselves. I hope our community feels more empowered. And of course, knowing you're out there as a resource is very reassuring. So thank you.
You're welcome. I'm very happy to hear that. And I'm very happy to be here talking to y'all.
Lovely. Thank you everyone so much for attending. Now, as you leave our webinar today, the evaluation for today's program should pop up. So please do take the time to complete that evaluation. Please give any ideas you have about future programming. And then we will send out copies of Hannah's presentation via email. And we'll send out a link to the recording as well.
And anyone, please feel free, like you have my contact information, feel free to reach out to me specifically at any time if you just have like a little question, if you didn't feel like asking the question now, like I'm always happy to talk to people.
Amazing. Thank you, Hannah. Thank you to our transcriber, to our interpreter. We appreciate all of you, and to our audience as well. Enjoy the rest of your day, everyone.